Welcome back to the Liability Lounge After Hours.
Hello, folks.
My name is Bryan. With me, as always, is Joe. And we brought in some extra firepower today. Colleen Kosluchar from our office, the Trenti Law Firm.
Hello, folks.
So, it's Groundhog's Day.
It is.
And so we thought, what better way to do that than to dig into some of the legal aspects of Groundhog's Day. And I think maybe a good place to start. Well, obviously, Joe and I are wearing our Iron Range tuxedos, so we're ready. We're ready for anything. But maybe, Joe, should we dig into the movie Groundhog's Day a little bit?
Yeah, that's it. The movie didn't make it famous, but it brought to light a lot of things that we, should know about Groundhog's Day.
So I hope everybody's familiar with the movie Groundhog's Day that stars Bill Murray. The thing that Joe and I and Colleen thought was interesting about this movie is it takes an interesting proposition from a legal standpoint. If somebody's not familiar, the movie Groundhog's Day essentially is Bill Murray is a weatherman who's assigned to go to Pennsylvania and cover the official Puxatawny Phil observance. And on February 2nd, on Groundhog's Day, and he gets caught in a loop where he keeps experiencing the same day over and over again. And you kind of see a development through the movie about how this affects him. At first, he kind of sees it as a curse, and then he just starts engaging in all this wild activity, reckless behavior, doing some pretty crazy stuff, manipulating people. And then ultimately, as the movie continues, he uses the continual loop of the day as an opportunity to kind of better himself. He, I think, learns the piano, learns some French, and as it goes through, ultimately he's able to break out of that cycle. But that movie kind of put an interesting idea in our minds. What's the legal effect, or what would be the legal effect if a person was living the same day over and over again?
Yeah, we thought of some clever ideas that are, factual basis, could involve you and I today. Statute of limitations, some criminal stuff. Do you have regular intent? Just a couple other things that we want to talk about. Is it pre-existing? Can it be pre-existing? Because you have the same thing every day. So where do you want to start, Bryan? Just with statute of limitations, maybe?
Yeah, let's talk about the statute of limitations. Colleen, pop quiz. What's a statute of limitations?
It's a legal bar to an action if you don't bring it within a certain time period.
Okay. And so obviously the question becomes, what would the effect of a statute of limitations be if you're experiencing the same day over and over again?
And it could go like to a medical malpractice where you are treated and you don't know the doctor did anything wrong until maybe 4 or 5 years later. And it's the same scenario. When does that statute start? Does it start the day the doctor did something wrong, or the day that you actually woke up and discovered it by whatever means?
Okay. And so in a medical malpractice claim, Joe, what is that statute of limitations?
It's 4 years. 4 years for medical malpractice and dental. You have to be concerned, though, if in fact there's a death resulting from a medical malpractice, then it goes to 3 years. So you have to be, aware of that. But most good lawyers are, but the public should know that. It's general background.
Yeah, it's one of the most important things to know. If you believe you have a claim, you should always consult with an attorney or make sure that you're aware of what the statute of limitation may be for your claim, because statute of limitations are different based on what kinds of claims you have. Colleen, what's a standard statute of limitation in your practice areas?
Well, I'm thinking family law. I don't know that there is one. As long as you're divorced or you have kids of a certain age. But like contracts is 6 years, right? That's a different one. Probate, there's different types of probate that happen in the 3-year mark, ones that happen later, descent proceedings.
So, and then I think if you kind of research it, and as we learn, most common statute of limitations is 6 years, but there's some weird ones like
intentional assaults.
Right.
Yep.
It's 2 years. So if someone assaults you, don't be fooled that you have 6 years. It's a 2-year statute. Sometimes it could be a 3, but rely on the 2-year rule.
There's some real weird ones. Real estate, if there's if a claim arises out of an improper or negligent design or construction defect, your liability or your statute of limitations is 2 years from the time you discover it, but no more than 10 years overall. And so that's kind of a little bit of a different one. So, interesting question. If in Bill Murray's case, in the case of the Groundhog Day movie, what if your statute of limitations was going to run that day that you keep repeating?
Well, it would be, in his world, it would be told. That's the legal term. But in the real world, it wouldn't be told. It goes by. So if you think you have an excuse, pretend you don't and go by the real world.
What do you think, Colleen?
I agree. I guess if we're talking about a real world legal plane, right? If we're in a spiritual, metaphysical plane, whatever.
That's where we like to live.
Yeah.
No, I tend to agree. And it may make some difference. And this may become a theme as we kind of work through some of these silly examples. It may make a difference if you're the person who's reliving the day or if you're one of the folks that doesn't know that you're reliving the day over and over again. So, no, I think that's a good one and a good place to start.
Some other, it's really not statute of limitations, but a contractor comes out and does some work on your property and you're not satisfied and say it's a pavement issue and then the fall comes and he can't get it done and you get upset. And it repeats itself every day. You see this, it's not happening, and you get a promise, not happening, and you just call out to someone else and say, fix it, and that's the wrong thing to do. You've got to give that contractor a right to come and fix it. It's almost like a statute of limitations. You must give him a right, and obviously a reasonable right. I mean, you can't, have him come out and redo your driveway in November, December. That's not reasonable. But some other contractors wouldn't do it. And if you hired them, they'd come out and do it, and you would still then you'd have to pay the new contractor and the old contractor. So be aware of that.
Yeah, it's called the right to cure. It exists in a lot of contract cases, and it's part of a larger duty called the duty to mitigate, which basically says if you're going to claim damages in a lawsuit, you have an obligation as a person claiming to make sure that you take reasonable steps to make sure those damages aren't artificially increased or that you keep them as reasonable as you can. So living the same day over and over again, Joe, how do you think that would affect the standard of care?
Well, there probably wouldn't be any. You wouldn't have to fix anything. You may encounter the same icy spot every single day, but other than that, I don't know. So standard of care, that is the standard that a reasonable person would exercise when you encounter. Number one, encounter some sort of an obstacle. And number two, if you're obligated, we'll hail back to our premise liability. If you're responsible for making sure it's safe, it's the standard or the level of care that you've got to exercise to make sure that it's safe. And this is one I particularly think it's going to change whether you're the person that's reliving the day or whether you're the people that don't know that the day is resetting each midnight. Standard of care is kind of an interesting thing. The more you know, the more that standard of care may change. I think Joe's example of an icy sidewalk is a great one. If I'm living the same day over and over again, and I come out of an establishment and I slip on an icy sidewalk and fall down, the standard of care may be one thing. I may not have had any obligation to know that. And the person whose duty it is to maintain that sidewalk may be responsible to me. Now, if I've walked out of that same establishment that same morning in the same conditions 900 times, and I've fallen down on the ice 900 times, the standard of care may be a little bit different because I've got some knowledge that I should utilize to protect myself. Exactly. So, okay, so why are we dressed up in these hunting clothes and so forth? Not to switch the subject, but it's still a Groundhog Day idea.
Well, it's a lot more comfortable than what we usually wear.
And why do I have a gun here? Am I going to shoot the groundhog? No. No. We thought that since we're going to talk about Groundhog Day and we'll get back to Bill Murray every once in a while here, we thought we'd talk about some of the laws regarding hunting and ATV use, snowmobile use. You still have a month of snowmobiling left, but it's just our segue into hopefully winter's over. Hopefully does he see his shadow when it's over, or vice versa?
Colleen?
I think it can be either or. And one, I don't remember which way it goes though. Which one, if he sees the shadow, it's
six more weeks.
After? Yeah, okay. That's what I thought.
And my snowmobile friends would be happy to hear
Yes.
that. So,
If he sees his shadow more than 3 years in a row, Joe, I think I'm going to try and hold Puxatani accountable here. So, it's Groundhog's Day is kind of the time when we start thinking about getting back outside for all of our outdoor recreation, whether it's the summer recreation or as we're prepared for fall recreation. And it just happens at the time we're recording this, it's plenty cool to be wearing this kind of getup. So, yeah.
The one thing talking about snowmobiles that I had a question the other day is trespass. Mm-hmm. What is, fortunately we have all these nice trails, but sometimes you go off the trail, and can you drive on someone else's land? And if you do, what are the penalties? It's there are trespass laws out there, as we know, right? And what are the rules about posting? I've got them in front of me, but if you haven't researched it, do you know?
I think you're required to post if you want to keep people out, right?
Yeah. How far from each tree do you have to post?
I don't know that, Joe.
Okay. Well,
Never measured it.
It's either, I don't have the exact number, but I think it's 100 feet, thereabouts. And some other states you don't have to put up a sign. You get a color, you register it, and you can spray paint every tree, and that means that you can't trespass. And if you do trespass, and if the landowner calls you on it and gets the sheriff out there or films you, and you don't have to get the sheriff every time, the first offense is $50.
Yep.
Second offense is a $200 fine. And the third offense is a $500 fine, and if you're hunting, loss of your license, hunting license for, I forget the amount of time, I think a minimum of 1 year. So, trespass and just don't do it. You never know who the owner of that land is, and you never know. So
Yeah, and Joe, to kind of tag on that, there's a couple of kinds of trespassing, and I join your opinion wholeheartedly. Don't trespass. If you're out riding the trails, please stay on the marked trails. A lot of reasons for that. Number one, you could be trespassing either intentionally or unintentionally. Outside those trails, there's less responsibility by the folks that are maintaining the paths through, and you're not necessarily an invitee in some of those other areas. So the standard of care people may owe you may be a little bit different, and you don't know what kind of obstacles you may encounter.
Yeah, and I just pulled up my notes. It's you have to post it if you're not in a wooded area 1,000 feet, and if you are in a wooded area 500 feet. So it's you got to post.
And that's one variety of the trespass. The other is if you do get off the trails, or if you do find yourself in an area and somebody approaches you and says, "Hey, I'm the landowner," and you've got to remove yourself, you've got to get off the property. You can't just say, "Hey, you don't have your signs up every 1,000 or 500 feet." Once you have actual notice that the owner doesn't want you on the property, you've got to leave. And so those are the two ways you can get in trouble by trespassing. And we have to advise everybody, don't trespass.
And then obviously we're talking about snowmobiles. Snowmobile laws are the same as driving laws as far as DUIs. It's if you get stopped, it's a .08, and if you get stopped on your snow machine, it affects your boating rights and your driving rights. And I'm not sure about your commercial vehicle on a snowmobile, but probably so. But I know it's your driving and your boating. There's same effects as if you're driving a car.
Yeah, I think it would be the same effect on recreational vehicles. Minnesota law used to, and Joe, you probably remember back to the time when it used to differentiate between...
Are you aging me?
No. Wait till you're my age, Joe. It's terrible. The law used to create a distinction between off-road vehicles, recreational vehicles, and this wasn't all that long ago. It was probably 5 years ago. Right. And if you you got a DWI or an impaired driving offense on one of those recreational vehicles, you weren't allowed to operate recreational vehicles, but you could still have your standard driver's license and continue to drive your automobile. Now they lump them all together. They treat the whole thing as one system for purposes of license.
Snowmobile, ATV, and boating, and cars, right?
Yep, absolutely.
Motorcycles. Okay, so driving a car, the first rule is that the officer has to have probable cause he made some type of law violation. Yep. Is that the same in a boat, a snowmobile, or an ATV?
Yes and no.
Yes and no.
Favorite lawyer answer is it depends. So generally speaking, yes. There has to be some reason for them to have contact with you. Now, the qualification there is those reasons may look a little bit different. And I suppose another concept to bring in here, I've heard in my practice, the person that had contact with me was a DNR officer, and DNR officers don't have the ability to give me a DWI or stop me for a DWI. Not true. DNR officers are law enforcement officers and post-certified, so they have the same abilities. It's just that their enforcement efforts typically focus on a different set of laws and rules and regulations, but they still can stop you, they still can have contact with you, and they still can test you and write you for a DWI. And that's the reason I bring that up, is the way that a DNR officer may have contact with you may be a little bit different than a law enforcement officer. When you encounter a DNR officer and you're out in the field, if you're out boating, if you're out in the woods on an ATV, if you're dressed up like Joe and I are, or if that DNR officer has any reason to believe or has probable cause to believe that you're engaged in recreational activity that's licensed by the state of Minnesota that they regulate, they can have contact with you. So if you're out fishing, they can stop and check your boat for fish. If they see you in a boat with fishing rods and all that, they can have contact with you. In fact, DNR officers a lot of times can have contact with you just to make sure if you're out in a boat, you've got your life jackets and your proper safety equipment in the boat. But even after let me ask you this. Joe, if after you leave the lake, say I'm landing my boat, I've got it pulled up on the side of the boat landing, could a DNR officer still come up and talk to me?
Yeah, I can. As long as you're coming out of the water with the boat, he can check you for life vests, so forth, and especially if you have a fishing rod or if you have a live well, he can check your live well. That's unfortunately a Minnesota lawyer fought that years ago. He put up a nice fight, and the Supreme Court said no, they can, because you're engaging in this activity, specifically fishing. And so they do have a right to check your boat once you come out of the water. Do they have a right when you're 20 miles down, stopped at the local hamburger spot?
Yeah.
Probably not, because you're not engaged in that activity, unless they got some tip that you're transporting illegal fish. That's a different story.
Well, I have a question for you guys. I don't do this area of law. If you're on your private field driving an ATV drunk, are you in trouble then?
Yep.
Okay.
Yep. If you're on a lake, your own property.
So it doesn't matter if it's a public road, private road. There's no distinction here.
No.
Okay. Because I lived up in Alaska, and that was a big one up there back in the day. I'm going to age myself there. Yeah.
I think it changed.
Yeah.
I think you had that right.
So you could take it one step further. If you're driving a motorized cooler on your own property impaired, we've got case law in Minnesota that motorized coolers, motorized recliners, they can all be the subject of
Can't have any fun anymore.
Golf carts. Lawnmowers. Even a guy in Proctor, wasn't he driving his lounge chair?
Lazy boy.
Lazy boy.
The lazy boy case.
And he got the DUI.
Yep.
So, but okay, so fishing's a different thing, because you're actually taking, a fish property of the state. But what about just driving an ATV on a trail or a snowmobile on a trail? Do they have a right to just stop you and say, I want to check everything? Or do you have to, they catch you speeding or see that your license isn't updated?
Yeah. So you have to, if you're in compliance with all the laws and visually they can see that you're in compliance with all the laws, they still, they'd have to just kind of let you pass. They've got to have some probable cause, some reason to have contact with you. Although the caution is when you're out trail riding, it's easy to miss one of those licensing requirements, or your license, if it's displayed improperly, all of those things can form the basis for a contact. And once an officer has contact with you, they have the ability to do those, to make observations and do those tests, and ultimately could end up in a DWI. Going back to the search issue, Joe, out fishing, they can check your boats, they can check you on the landing. How about ice houses?
Ice houses, no. In fact, another lawyer challenged that. He was in his ice, or a client of his was in his ice house. DNR knocked and entered, and he was fishing illegally. He was ticketed, and they fought it, and the Supreme Court said, no, that's a private place, almost identified it as a home, and they would have to have a search warrant to enter. But most Minnesotans are saying, yeah, come on in. And you give them that invite, and they can search and ticket you for whatever they want. But no, they can't illegally enter without a warrant.
I was a little concerned as you were starting out there, Joe, that the lawyer had challenged the ice house rule. I'm thinking we're giving lawyers too much time off. They're out on boats and they're out at ice houses all the time.
Oh, no.
Should be spending more time in the office, right, Colleen?
No. You need to have balance.
Yeah, fair enough.
Oh, what else? So let's talk a little bit about gun laws since we brought the gun. What about transporting guns? You're out on the shack and you have four guys, four different opinions on how you can transport the gun. Is it different from transporting it in a car, truck, to an ATV? And again, I'm going to throw you on the spot. I researched it, so I know the answer. but pretend you're at the deer shack and this comes up to you.
Okay. So, and let me know if I get it right or wrong here. Transporting a gun, even if you're out hunting and you're transporting in your car, the gun has to be unloaded and in a proper case designed to hold a firearm. If it's unloaded and cased, you can have it in your back seat, you can have it in your front seat, you can do whatever you need to do because it's not immediately accessible to you. You're going to get in trouble if it's uncased and loaded. You're going to get in trouble if it's stuck in the case but loaded. So be very careful in transporting those firearms.
And what about using your vehicle as a deer stand? Can you hunt out of your vehicle? If it's stopped, you're not transporting anything.
It depends. The general answer is no. So if I were to shoot from my vehicle, it would, most likely it would be an inappropriate harvest of an animal. That being said, if you suffer from a disability, there are some instances where there can be exceptions, but it wouldn't necessarily be rifle hunting. It could be crossbow. It could be some of those things. But those are very limited in scope, and you really have to work with the DNR in order for those to be a potential. So,
correct.
Generally speaking, I think the rule is you have to be afield, which means outside of a vehicle, off the public right-of-way and into the woods.
Yeah, and I agree with that 100%. But I do believe, and I think the law supports it, that you can use your vehicle if you're stopped and not transporting. You can sit in your vehicle with a loaded gun, but you can't shoot from that vehicle. You have to get out. You have to be properly dressed, and then make the shot. So, and one small little fact regarding someone with a permit. This came up last season with a call from a client. He said, I have a permit. Can I shoot a doe in our area, Virginia area? And the answer was yes. And many of his partners in his hunting party are saying, no, you can't. But if that district or that area says that you can have a lottery for an antlerless a doe, you can shoot a doe. But if your district says no doe hunting at all by lot or anything, you cannot shoot a doe. No. Yeah, so that was kind of a interesting fact. It was kind of hard to find, but he did have the proper credentials to shoot a doe.
So before we leave this topic, there's a couple of danger zones, a couple of spots that I think we want to make sure that we hit, just because there had been some confusion about them, and there's been some locally at least, I know that it's been kind of a higher priority to enforce, and that's transporting firearms, whether hunting or not. If you have a permit to carry and you're carrying a firearm, just make sure that you continue to obey all the other laws, that you're not using it for other hunting purposes. And if you've consumed some alcohol, it's being taken very seriously right now, and we encourage everybody, don't carry your firearms if you've been consuming. If you get above the .04 level, I think is the threshold. Number one, law enforcement takes it very seriously. They should take it very seriously. But then the area where I've seen it in my practice a lot more lately is somebody's got a permit to carry. They don't have the gun immediately on their person. It's loaded in the center console of the car or something like that. You're still going to get in trouble because the law enforcement considers that to be immediately available to you and for your use, and they're going to treat it just as if you had it on a holster in your person. So.
Okay. Interesting. What about using drones for hunting? That's a no-no too. You cannot do that. It's a computer assistant hunting gadget, and it's prohibited. Can you use your cell phones? It's radio. The law reads it's radio equipped. You cannot use radio equipment to take game. Yeah. Is a cell phone a radio equipment?
If you're using it to take game, I would say yes. And who was it that got? Was it Babe Winkleman?
Yes.
Or there was a
person.
famous a relatively well-known outdoorsman.
We don't know who for sure for defamation purposes.
That's fair.
Somebody like that.
Someone
maybe,
like that.
Yeah.
So go ahead. Someone.
So and what the prohibition is using the radio technology. Walkie-talkies are very common to coordinate taking game. Now, if I have a cell phone in my deer stand or even a walkie-talkie in my deer stand, and I shoot a deer or take an animal, and I need to let somebody know that I've taken it or notify my party that I'll be out of my stand so they can be more safe while I'm out moving around, by all means, you can send a message saying, I've got a deer, I've got one down, or I'm doing X, Y, and Z, or let's head up for lunch. But you can't get on the radios or the walkie-talkies or the text messages and say, I just saw a deer in this area, go to that spot and come back to, coordinate the drive or whatever else. That's where you're going to land yourself in some trouble.
Yeah. So, well, what else about Groundhog Day that we can talk about, enlighten ourselves or?
So I was using his shortened version of his name because he and I are buddies. And so I've got permission to do that, I think. His actual name is Punxsutawney Phil, Seer of Seers, Sage of Sages, Prognosticator of Prognosticators, and Weather Prophet Extraordinaire.
And we promised not to shoot at him.
Well, you can't. Minnesota has laws. Minnesota's laws.
No. Could you shoot him? No?
Most likely not.
What if he were a pest or a nuisance?
If he were a nuisance animal, you probably could, but you'd want to communicate with the DNR before you did it. So you also can't capture a live groundhog from the wild and just transport him in your car. We have specific laws about that, which makes me curious why we had to get those on the books.
So he can't become your family pet then?
No, not without a permit to take him. And if you're going to use him for an entertainment display or an entertainment purpose, we also have a very specific law in Minnesota that is not an exception. So if you're interested or in the business of creating a competitor to Punxsutawney Phil, probably get the permission of the DNR and get a permit to take whatever animal you're going to put up against his weather prediction abilities.
Well, Bryan, thanks for another enlightening podcast of Liability Lounge After Hours. I think it's about time we take a break and go have one.
Sounds good. Thanks, Joe, and thanks for joining us, Colleen.
I learned a lot. Thanks, guys.
And as always, if anybody who's watching or listening to our podcast, if you have suggestions for us, if you've got topics that you'd like to hear us cover, if you've got comments or response for us, please send us a message and let us know. If you enjoy our podcast, please like it and follow along.
Tell a friend.
Tell 2 friends. Tell your 10 drunk friends that will come and test your product or your premise liability.
Yeah, there you go. So
thank you again, and we'll see you next time.